I was looking for my mouse, but then I realized I don't have a computer. So, Cross. Yes, ma'am.
Good afternoon. I'm Emily Medlin. I represent the United States Department of Defense and all other federal executive agencies. My question today will be directed at Mr. Chapman. And specifically, I want to discuss with you the rate credit that's in the customer benefits plan. It's my understanding that all eligible SCE&G retail electric customers will receive a one-time rate credit totaling $1.3 billion. Is that correct?
Under the original customer benefit plan, they would receive a rate credit in the form of a check for that amount, correct?
And I want to direct you to page 8, lines 20 to 22 of your direct testimony.
I'm sorry, page 8?
Yes. Page 8, lines 20 to 22. And you state that translate to an estimated $1,000 per residential electric customer on average, and significantly more in terms of usage consumers in the residential, commercial, and industrial customer classes. So those customers that have a significantly higher usage will receive a significantly higher rate credit than $1,000. Is that correct?
That is correct.
And now I want to direct you to page 10 of your direct testimony, lines 16 through 17. In that you say Dominion Energy and SCE&G are receptive to changes in the administration and or allocation of these payments. Is that still a true statement?
It is still a true statement.
Are you aware that if the rate credit is issued as a check solely, that my client, which includes, among others, Fort Jackson, the VA, federal office buildings, and courthouses, will not directly benefit from this rate credit because the check would have to be turned over to the United States Treasury?
Directly benefit, that is my understanding.
And knowing that federal customers in South Carolina will not benefit from the rate credit or see any direct reduction in their utility costs, despite the fact that they paid for the new nuclear development project costs over the years through their rates, would Dominion and SCE&G oppose customers having the option to receive the rate credit either as a check or as a credit on their electric bill?
If I may address that in this way, the structure of the payment of the $1.3 billion is intentional and is a requirement of us, of Dominion Energy, on a consolidated, combined basis with SCANA, receiving the appropriate and hopefully advantageous treatment from financial analysts as they view the impact of that $1.3 billion. That advantageous treatment is available only in the form of sort of a one-time cash payment, as opposed to credits on any customer's bill over what inevitably would be a number of accounting periods. So I wanted to share that it's not a random thing. It's not something that relates to convenience for the execution or the administration of those refunds. There is a reason for it. To answer your question more specifically, you're proposing an adjustment to the customer benefit plan for a specific customer or a few customers. And I guess we would need to take into consideration any such modest alterations in respect to an overall proposed acceptance or revision of our plan when that time comes, if that time comes. Okay,
so Dominion would be open to revisions that would, in essence, protect federal customers to where that money would not go out of the state of South Carolina?
We are unable to provide in our proposal that accommodation to all customers, unfortunately. But I do agree that there are some unique aspects of the situation in which your clients find themselves, and we would be interested in making sure we could accommodate where possible.
Okay. Would that also be for, if it's allowed, just allowing the option for non-residential customers, or certain rate classes within the non-residential?
Again, it's hard to address specific suggestions, not in context of the overall package of items in the customer benefit plan, but it would need to be as limited as possible.
Okay, but Dominion and SCNG, however, are open to alterations and differences in allocating the rate credit, not solely as a check, in order to protect the federal customers.
We would be happy to think through ways to accommodate the specific needs of those federal linked customers.
Okay. Thank you. That's all I have.
Thank you, Ms. Medlin. Other cross. Mr. Knapp.
My question's for Mr. Chapman. Mr. Chapman, I'm a pro se intervener here in these.
Make sure you get close to that mic, Mr. Knapp.
Thank you very much. Appreciate it, Mr. Chairman. I'm a pro se intervener in this hearing, Mr. Chapman, and I want to talk more about securitization. But before I get there, since you are the finance guy for Dominion, can you tell us how much money Dominion spent on radio, TV, and newspaper advertising in South Carolina in 2018?
Dominion Energy maintains, very specific records on those matters, but I am not so familiar that I would have the number at the top of my head.
Could you give us an estimate?
Unfortunately, I'm just not familiar.
Could we get familiar at some point and report?
We absolutely have those numbers. I just am not familiar with that specific item.
Mr. Farrell will be up a little bit later. Is there a possibility that you could get the number before he testifies?
We can try.
Thank you very much. I appreciate that. All right, securitization. You pointed out in your testimony that South Carolina law does not presently allow for securitization. But we have heard testimony here and even comments from the commissioners indicating that the commission can include securitization in some manner in an order. Do you believe that they can do that?
I'm not an expert in that matter, but it would seem to make sense, yes.
Okay, thank you very much. This morning, Ms. Edwards pointed out that Dominion has supported securitization in the past. In your testimony, you say that securitization was heavily used after the Great Recession. Why was that the case?
If I said that, I misspoke. What I meant to say is that it was very heavily used across all kinds of industries and across all kinds of asset classes to securitize in the capital markets, including on very large transaction bases, prior to the financial crisis.
I see. Okay.
Following the financial crisis, it's become a more modest activity level in that area.
And so before the Great Recession, why was it used in abundance?
I have quite a few thoughts on this. The receptivity to securitization activity is driven not only by commissions and companies, but most importantly by investors. So the investor appetite for those kinds of levered and highly structured transaction, in my opinion, has lessened since the financial crisis and the associated problems.
But it was an important tool at the time it was being used in abundance.
In certain situations, securitization works very well for all parties involved. My opinion is This is not such a situation.
All right, well, let's talk about that. So 17 states have used securitization. In 2015, the commission in Florida ordered securitization to be used to recover the stranded cost of an abandoned nuclear project there, reportedly saving their consumers $600 to $700 million. In fact, this past August, the state of California, lawmakers there approved the use of securitization to enable their utility, PG&E, to cover their costs of the lawsuits resulting from the 2017 wildfires, a liability that could go into the billions. So why have all of these other states determined that securitization is the best financial tool for their consumers, but Dominion doesn't think is the good tool here for South Carolina consumers?
Thank you. I was under the impression the number of states that have securitization as a tool is even greater than 17. I thought it was 21. But again, each transaction is driven by the facts and circumstances of the situation. So as I mentioned, in many other situations, it is quite an appropriate tool for all parties involved. In this situation, I believe it is not a workable solution for two reasons. One is that in order for Dominion Energy, as part of the proposed merger, to provide the significant customer benefits from its balance sheet, it requires some reasonable economic return to its balance sheet. And the securitization technology approach, as appropriate as it is in other situations, would take away, in this case, our ability to provide those significant investments and customer benefits and would not permit us the appropriate economic return to our balance sheet.
All right, thank you. In fact, you testified that securitization removes any equity, return on equity for the investment, and you've made that very clear that it's not that it can't be done, not that there's any hurdles really to get over for it to happen here in South Carolina, whether that be the pointed out some other investor concerns or breakage fees. It's simply a matter of Dominion needs to get a healthy return on investment from those recovered stranded costs.
Yes, sir. As mentioned, that is one reason in this case. There are other reasons that I believe it's not a suitable tool for this situation. Sorry, getting too close to the mic. And if I may, I've, of course, read and viewed the testimony of several of the witnesses who have presented on this topic over the last weeks. I would note that those testifying are experts in some form, some angles relating to transactions such as this, no doubt. But they are not experts in executing sophisticated capital markets transactions. And a securitization transaction is a very complicated and sophisticated transaction for the capital markets. So I'm also not a leading expert in securitizations, but I have in my career been responsible for raising several $100 billion of capital markets money and $10 billion in the last 10 months. So I have some familiarity with what drives or limits success in these kinds of matters. And as it relates to this situation, I think we've covered pretty well the lack of law which could be remedied, allowing for securitizations. And I think we've covered in testimony, but the other witnesses who were speaking to this point were certainly, it seemed, less familiar with the practical restrictions of what could be done with the proceeds of a securitization transaction by SCE&G. There were suggestions that proceeds of such a transaction could be used to invest in renewable power generation, which is noble. There are suggestions that the capital could just be distributed to the parent company. And Mr. Benz, I believe, suggested they could even use that to repurchase stock in support of their equity investors. Those are all noble goals. The reality, though, in this case is that as it relates to this point of the use of proceeds of a securitization, there are very important practical limitations, meaning South Carolina Electric and Gas has issued, in addition to other debt, $3.5 billion of long-term indebtedness to support NND. And I think everyone will admit that the financial profile of SCE&G is stressed. We're proposing some solutions to that, but it's stressed. If SCE&G were to carry out a securitization transaction, take the proceeds of that, and do anything with it other than repay its indebtedness, of which there is currently too much, the stakeholders that are relevant to the management of a healthy balance sheet would, for a better term, go crazy. Meaning that would be an incredibly creditor unfriendly move. The rating agencies would view this very negatively. The institutions that have already provided capital to SCE&G and would be expected to continue providing capital to SCE&G for years and decades to come would view it very negatively. So the concept mentioned, I don't believe analyzed, but mentioned by some of the other consultants regarding what could be done with the proceeds of a securitization transaction by SCE&G is simply not practical. To go a little further, and I promise not to spend too much time on this, in addition to enabling legislation and the use of proceeds, it's very important in transactions like this to, again, not only think about what legislation could be passed and what commissions could support, but also realistically consider what the buyers of such securities, what they want and what they require in order to invest in such transactions. And these are sophisticated investors. They have their own fixed income analyst, et cetera. But one thing they certainly require is a high credit rating. And I don't mean the credit rating of the company. I mean the credit rating of the specific security that results from this legislation and regulation, the actual debt that is securitized that's being sold to the public. And in the securitization market, given who the investors are, institutional investors, many of them rates investors, so the kinds of investors that invest in treasuries and state-backed securities, the sweet spot for that market is AAA. And I'm sure if you look around the country at different securitization transactions, including the one you mentioned for Duke Energy in Florida, they are rated AAA because the facts and circumstances of those situations support a AAA rating. And there are various of those that are embedded in rating agency methodologies across rating agencies. But let me speak to just two that I think in particular are relevant to this idea for SCE&G in this case. One is, again, it links back to the legislation, but just as a starting point, any rating would require that there be that legislation that guarantees that the financial burden of repaying the debt is the ratepayers. So that's just a foundational matter for securitization. So when rating agencies and financial analysts look at a securitized debt instrument, they will look at the rating agency, the rating, which hopefully is AAA, but this matter feeds into that rating. And I'll paraphrase a Moody's report on that very same Duke Energy Florida transaction you mentioned. And one matter they noted, which was in support of that AAA rating in that case, was the likelihood, which was highly likely in that case, in their view, the likelihood of successful legal, political, or regulatory challenges going forward. And in that case, they viewed that was a very low likelihood. I would argue in this case, given, again, the facts and circumstances in South Carolina, they may reach a different conclusion. For example, they would be highly aware of examples like the political leadership in the state when it comes to the financial burden being the ratepayers, saying things like, send me a bill that places the burden on the ratepayers and I will veto it. And similar statements and tweets and the like regarding this situation, which could all be totally fine. But when a rating agency reviews the likelihood of successful legal, political, or regulatory challenges over a very long period of time, I think it's fair to say that they would not come in that specific respect to the conclusion that it should be AAA. And let me come back to what that would mean if it's not AAA. The second matter, again, it's just of two matters to mention, is the size. And the size, as noted many times in testimony, the size, depending on how much would be securitized, up to the $3.5 billion, would be multiples of the largest such utility securitization transaction since the financial crisis. It would be very large in absolute dollar terms, which is a negative for the credit based on the rating agency methodologies and the things that are written. But it would also be very large in relation to the size of the amount that is mandated to go as a specific line item on the customer bill. And in other cases where such transactions are feasible and the ratings tend to be, again, AAA, the sweet spot for the market, that's not the case. They're both smaller in absolute dollar terms and smaller in terms of the percentage of the total bill that's represented by this non-bypassable charge that's authorized under the legislation. So here, given the size of SCE&G and given the size of the matter that needs to be addressed with the indebtedness that's in place at SCE&G, the relationship is not supportive of that kind of AAA treatment in my view. So that links to the results. What happens if you have a...
I feel like we've gotten pretty far afield of the question that was asked. I can't tell if he's reading a prepared statement, but I'd ask that the witness just answer the question that was asked. We're all taking a lot of time here.
Okay. We're going to give him a little more time. I think he's entitled to explain his answer. And yet you want to... Okay. So...
I know enough to sit down after that.
So to summarize, regardless to summarize, in my view, given these factors in this situation, the resulting securitization would probably not be a AAA rated piece of paper, as it normally is and probably is in almost all the cases that you've mentioned in other states. So what does that mean? That means many of the investors would not be interested in that. Doesn't fit their parameters. Doesn't mean it couldn't happen, but it would need to be smaller in size. It would need to be shorter in tenor. And shorter tenors means you're amortizing the amount in fewer years, which means the portion on the bill goes up, which is another problem. And it means higher pricing. And it's not clear to me, given those constraints, those market constraints, which were not addressed by other witnesses on this topic, it's not clear to me that given those constraints, it would result in a attractive financing, even as compared to what SCE&G has already done. And again, just to finalize, regardless, these are all matters that are, in my opinion, make this not a feasible approach if the commission was to pursue this kind of transaction. But regardless, it's not workable within the construct of the benefits that we're providing from our balance sheet and the economic return that we require.
Well, thank you, Mr. Chapman, for the detailed response to that, because I'm sure that a lot of that will be things that the commission will want to take into consideration. I do want to address a couple of things you pointed out. You talked about those who hold bonds right now for SCE and G. There are early penalty payments on those bonds. Would that be correct?
On almost all bonds, but
Okay,
including on those. That's
So it's not like the investors are going to not get what they were told that they could get.
The other witnesses on this topic
Just,
have
if
been
you just answer yes or no, that'd be great.
yes.
Okay, thank you. And I'm sure that the commission can take in consideration your other concerns, especially about what could the company do with the money they get from securitization. I'm sure that could be in order also.
Exactly.
All these other states who have used it have used it successfully. I mean, I'm assuming you look at Florida, they claim a very good response, and now you got California doing it. By the way, California's PG&E is almost junk bond status, but they're going to move forward with this. And any legislation that would be crafted to allow securitization could take into your consideration your concerns. Could they do that?
Could you repeat the question, please?
Could legislation that is crafted to allow for securitization take in consideration your concerns?
I'm not aware how legislation would, in this case, alleviate the investor and market-related concerns, but I concede that could be.
Okay. You mentioned leadership, political leadership in the state. You made a quote from our governor about what he said regarding legislation. And you say, well, with the grounds that the investors will be looking at that, what's the political lay of the land, and does that make it more risky? But the reality is, once the legislation is passed and the governor vetoes it or doesn't veto it, and it becomes law, all that concern that you just mentioned on that point one, at that point, go away. Would that be correct?
I don't agree with that. In every securitization transaction, the enabling law is passed, but my understanding is that credit analysts, market participants, credit rating agencies still, after the law is passed, focus on this issue of challenges, political regulatory challenges on a go-forward basis. So that is even in the cases where enabling legislation is already in place.
Okay. So it seems to me that whoever would write that law would have to make it very tight so that it could not be challenged in court. Or not successfully.
Politically, that's beyond my
Okay.
expertise.
All right. Well, thank you. And the second thing, you talked about the size of the securitization. You do know that ORS is proposing less than $1 billion of allowable recoverable cost.
I'm aware of the ORS optimal plan, which outlines that kind of level, yes.
Okay, so that certainly is not the $2 billion to $3 billion that you were referring to. That may not be able. That the size would be too large for SC&G to use securitization. I mean, that comes down below $1 billion to right in the realm of maybe a lot of these other successful securitized bonds.
The $3.5 billion was in relation to the debt that exists today on the utilities balance sheet. The size, I agree, it would put it from a market perspective in the range of transactions that have happened in recent years. However, when it comes to the size of a transaction, to use that example of $1 billion or so, in relation to this utility, or in relation, after accounting for interest expense and amortization, in relation to the total bill, I don't know what that would be, what the constraint dividing line would be, if there is a bright line.
But if it was SC&G, if it was a combined Dominion and SC&G, that less than $1 billion securitization would be nothing.
That's not the correct way to look at that. It would be the financial analysis of the SCE&G balance sheet, unrelated to all the other entities within Dominion Energy.
Okay, very good. Mr. Chapman, thank you very much.
Thank you. Thank you.
Thank you. Any other? Mr. Anselmo.
Thank you, Mr. Chairman. I'm Michael Anselmo. I'm the legal counsel for the speaker, and I have a few questions for you, Mr. Pruitt, about the comparison between the two customer benefits packages. if you could help me with those so I can make sure we understand the differences. We've been calling the original benefits plan Plan A and the alternate benefits plan Plan B, so I'll stick with that if that works for you.
That works.
My understanding under the Plan A is that the rate base would move to $3.3 billion approximately.
Approximately, that's right.
But in Plan B, the rate base would move to about $2.772 billion, correct?
That is correct.
And Dominion chose the $2.772 billion number because that is the same disallowance date of March 12, 2015 that ORS recommended.
That is correct.
And if you selected that date, that really would remove the prudency determinations or the imprudency determinations from the Commission's purview.
That's right. That was the intent.
And then the cost of debt, or excuse me, the return on equity in Plan A is 10.25%.
That's right.
And that's the same number that was chosen under the BLRA, all the rate to return imposed thereunder.
Yeah, per their last approval, that was the rate.
And the return on equity in Plan B moves for the first time, I believe, under 10% to 9.9%.
That's right. As part of Plan B, that's what we picked.
Rather close to the 9.1% offered by ORS.
Yeah, we picked 9.9% in Plan B.
Okay. And then the cost of debt in Plan A was 5.85%, if memory serves.
That's right, and that's the same reason that was the last approved BLRA rate.
And the cost of debt under Plan B moves to 5.56%.
That is correct.
That's also the same number proposed by ORS for resolution of the matter.
That's right.
Gotcha. And then there are some givebacks that I would like to, actually, if we could circle back to one thing. So the rate base, the customers would be repaying about $550 million more in rate base under Plan A than Plan B, correct?
That's right, in terms of just rate base.
Yeah, just rate base.
Yeah.
And then they'd be repaying it with a higher return on equity attached to that compared to the Plan B.
That's right. If just that rate base and return in isolation, that's right.
Thank you. And then there are various givebacks in Plan A. Plan A returns 1.3 in cash. I think we've been through that a lot.
Mm-hmm.
And of the about $2 billion paid to date by ratepayers, that's what, about 64% back?
Approximately.
Borderline. And then Plan B gives back a total of $1.91 billion, correct?
That's right.
So that's $600 million approximately more than Plan A?
In nominal terms, yeah.
Yeah, in nominal terms, spread over time. But yes, total givebacks would be $600 million. And that's, and then there's a Trump tax cut, the Tax Cut and Job Act component that are comprised in each. And I believe they're consistent. The Dominion's offer to pass through currently 3.5% in tax cuts relief immediately, then with a true up in approximately 2 years at the next rate case.
That's right. That's the plan based on our analysis of the act.
So currently, conceivably in another 2 years, there will be additional reductions to rate as you pass through the full amount of the tax cuts.
Yeah, once we fully evaluate it, and it'll be reviewed in the next rate case.
Now, would it be a fair characterization to say that Plan A could be characterized as more short-term immediate relief to ratepayers because of the cash up front?
I think that would be appropriate.
And that the Plan B really provides lasting and long-term relief given the duration of the givebacks and the total value that we just went through?
That's right.
Okay. Now, there's been some discussion earlier about net present value between the two offers, which net present value, in my opinion, can get a little complicated, but here it seems rather common sense to say that Plan A, of course, would have a higher net present value because you're giving back $1.3 billion presently, correct?
That's right.
But if you look at the overall net present value, they're rather close together ultimately when you're talking in the scale of billions of dollars.
That's right.
Okay. And net present value is not the determinative factor in analyzing value of one of these plans, is it? It's a factor, but not the determinant factor.
It is a fact. That's right. I would put it that way.
There are other concerns that the Commission has, such as really policy decisions of what type of relief, short-term, long-term relief, would be best served for the ratepayer, correct?
That's right.
Thank you. And Dominion believes that ultimately the benefits to the customers are overall equal, just provided in different short-term versus long-term mechanisms.
That's right. That's what we did when we came up with Plan B.
Well, if we could just get the rate a little lower, I think we'd be in business. No more questions.
Thank you.
Thank you, Mr. Anselmo. Other cross. Commissioners. Commissioner Elam.
Good afternoon. Mr. Chapman, can you tell me, for a few categories here, what changes would need to be made in the future as a result of the merger if it's approved? The accounting systems for SCANA, what changes will need to be made there?
As was mentioned earlier in this proceeding, that is one of the critical areas for post-merger integration. So that will be a very in-depth process that will take a few years to consolidate the accounting systems across SCANA entities, including SC&G and Dominion entities.
So you see a fair amount of differences that would have to be resolved now?
Yes, sir. And I don't mean necessarily accounting differences, but technology differences in the way accounting systems work. It's different, totally different platforms, unfortunately.
Just like specifically written software that each company may use is just not compatible? Is that what you mean?
Exactly. SCANA is a PeopleSoft company, and we're a SAP company. I wish I didn't know that.
Well, and about computer systems, I mean, does it go beyond just the accounting systems that there are a lot of differences in IT architecture?
I'm less familiar with those areas. I'm sure there are when it comes to IT and the forms of cybersecurity and things like that. Doesn't mean one's better or worse, but I'm sure there are differences that need to be harmonized.
Okay. What about office space? As in, you may end up with a lot more office space in Casey, empty office space. Is that a part of what you mean by having to do integration there?
It's not what I meant. It is, of course, an issue. Decisions like that would not be made for some time.
Okay. Budget process is different?
I imagine they're very different.
You don't know now?
I don't know now.
What about allocation percentages of both SCE&G and Dominion? Will it just be based on customers, or how do you do it for your other subs?
When you, I probably don't know the answer on any basis, but which allocation do you mean? Allocation of service company expenses and the like?
And the like, yes.
Yeah. The depth of my knowledge there is that is a very complicated area where we and probably SC&G and SCANA have quite a few experts involved. I imagine there have to be differences between the systems, but I'm not personally familiar.
You were speaking with Mr. Knapp about the Florida securitization. Do you know what was done with the proceeds in that case?
I do not know.
And any of y'all can take these if it's because you start to touch each other, and I'm not under the same ground rules as the lawyers out there.
That's very helpful.
Merger savings. Is it you say that you can't really say what merger savings you're going to have now, correct?
Correct.
But it's fair to say it won't be nothing.
With your permission, I'll give a little more color on that. Of
Sure.
course, that's fair to say. It won't be nothing, and the cost to achieve them will also not be nothing.
Which cost you're not passing along.
Absolutely correct. But if I could say it this way, we don't know what it is, but the way we think about it is that any number that represents savings between now and the first rate case in 2020, into 2020, is in the customer benefits package that we're offering. And there was suggestion by another witness, Mr. Collin, that the traditional approach is in utility mergers is for longer term, even for such merger savings costs to be identified and shared between customers and shareholders. And just to clarify, we're not proposing that. We do not have a number, but whatever that number is will be clarified in the first rate proceeding at the end of 2020, and we're not proposing that any of that be shared with shareholders.
Okay. Not now, you're not.
And by not doing it now, it's pretty limiting for future alternative decisions. Correct.
All right. Quite often in mergers, there is some target number set. You seen that?
I have.
Is the purpose of something like that to give the merging company some incentive to actually realize those merger savings?
I'm less familiar with that aspect. And I'm mostly aware with that kind of construct in situations where a utility merger is really about synergies, which many are, overlapping service territories, cost takeout, common dispatch of power plants, things like that. Those are deals that are about significant synergies. This deal, I would argue, is not about that. Very different situation.
It doesn't have anything to do with synergies. It's about just cash availability or financial worthiness.
It's about resolving an unprecedented situation in a way that provides for, in our view, fair consideration to all the stakeholders.
Okay, that's real noble. I get it. Your stockholders might not like hearing that.
They're one of the stakeholders I've included in that that bucket.
What incentive is there for the combined entity to realize merger savings unless they're held to some yardstick of what it should be? Something that could be changed as you get down the road, but without a target, what incentive is there to try to realize it?
Dominion's success long term in this endeavor, if it's approved, is based on the way we operate this business long term. The efficiency with which we do it from a capital perspective and an expense perspective. The incentive is to provide those results on behalf of our shareholders, which is the norm for IOU type utilities in my experience.
Okay. I'm maybe not sure who can address this, but has the IRS accepted all the NND losses?
I'll take that one.
I thought you might.
My understanding, it has not yet done that.
Okay.
The return for 2017 was just filed in September of 2018.
Okay. And there's no guarantee that they will?
No guarantee right now that they will.
Mr. Pruitt, on page 7 of your pre-file supplemental rebuttal testimony, you state that under both the customer benefits plan and the alternative customer benefits plan, reductions in the net operating loss carry forward subsequent to the merger shall be subject to Dominion Energy's ability to reduce its consolidated income tax liability. Is that correct?
That's right.
Okay. What happens to the carry forwards if Dominion cannot use them to offset its consolidated income tax liability?
If Dominion cannot use its income to offset it, I think it's very unlikely, but then the size of that will remain the same over that period.
How many years can Dominion carry forward net operating losses?
I believe it is 20 years, but subject to Jim Warren's.
It's 20 years.
Based on?
IRS.
20 years for net operating losses that were generated before 2018.
Okay. If Dominion is unable to use the net operating loss carry forwards, would it affect Dominion's ability to provide benefits under either of the customer benefit plans, Plan A, Plan B?
I think the only portion of the benefit that is giving back, how the DTA or deferred tax asset is utilized, NOL is utilized, I mean, that's the portion is dependent upon how much income is offset. I think that portion, is the only component of it that might slow it down. But otherwise, I think all the other cash components that we're providing in both plans, I think they remain the same.
So is Plan B any more risky than Plan A that way?
I wouldn't think so. I wouldn't think so.
Thank you, Mr. Chairman. That's all I have.
Commissioner Hamilton.
Thank you, Mr. Chairman. Mr. Chapman.
Yes, sir.
I think from your discussion with Mr. Knapp, I believe if securitization is a tool that this commission would ask the legislature for approval in this operation, that would be a no merger.
If there was yes, sir. If there was a requirement for us to securitize a portion of the NND in this case, that would very unfortunately mean the economics are not such that we would be able to accept it.
Okay, let me ask you another question then about the experimental rate that's been court tested that this commission had passed earlier. How is your Dominion's opinion on this rate?
That's a good question. It is close, $1.62. In both of our cases, there are so many variables that are not just the customer bill. It's some of it's tax related, some of it is years of amortization, and many other things. So it would, I can't comment on just that slightly different bill, but I would say that there's so many other variables other than the very important average bill level, typical bill, that it's not possible to really give a succinct answer to that.
I'd noticed in your discussion earlier that this didn't come up, so we feel like it's still alive. I have one other question for you. Let me find my notes. Mr. Elam did a good job on taking care of most of them. But how will the merger, if approved, affect the capital structure between Dominion and SCANA?
Yes, sir. That is a good question. It would not really impact the capital structure between, I'm sorry, did you ask between Dominion and SCANA or between SCE&G and SCANA?
SC&G.
Yes, sir. That would not be impacted at all. SCANA Corp would, in effect, continue to exist and would be an intermediate holding company within the Dominion family, which would own 100% of the common equity of SCE&G. So funding, which comes from Dominion, in particular in the near term, in support of SCE&G, would be provided through that entity, SCANA Corp, into SCE&G in a similar manner to the way it's been in past practice.
Thank you, sir. Thank you.
Sir, thank you.
Thank you for the information.
Commissioner Howard.
Commissioner Chapman, currently SC&G has no hedging program on its natural gas. Does Dominion have a hedging program on its natural gas?
Dominion has a limited hedging program. Most of our purchases of natural gas are through long-term contracts and fixed price arrangements.
Your long-term contracts, typically, how long are they?
That's an excellent question. I'm sorry to say I don't know the answer to that. I'd be happy to quickly find that out for you.
Yeah, I don't need a late file on, just be curiosity.
Okay.
Thank you very much.
Thank you.
Commissioner Whitfield.
Thank you, Mr. Chairman. Got a couple of questions for you, Mr. Chapman, and probably one for you, Mr. Warren, a little later. Commissioner Elam asked you a little bit about cost savings, potential cost savings associated with the merger, but do you have a number of what you think the total expected costs of the merger would be? An estimate?
Do you mean the cost of merger integration?
Right.
Other than large, especially as it relates to that number one item of accounting system integration, we do not have a current estimate.
I understand that to be large. There's been a lot of discussion with you and some of the attorneys that were crossing you about the investors that would invest in Dominion, invest in this venture, therefore investing in the abandoned assets, and about what type of return or what return those investors would earn. How does the company expect to recover merger-related costs? How does the company expect to recover those costs? If the ratepayers aren't absorbing those costs, how does the company expect to recover those merger-related costs?
Merger-related costs will be just treated on the account of basically shareholders, and they would not be recovered from any one party. It would be incorporated into the evaluation of the overall economics of a merger, but would not be passed on to any customers.
All right, I think you all have clearly stated that in your testimony. Been some discussion when SC&G witnesses were up about the trust that's set up for executive compensation. How can you share what you know about that trust, about it being set up, and how? Of course, that's been claimed that ratepayers would not pay that as well. But could you share your insights? We're talking about SC&G execs. So could you share how that your knowledge of that trust and how it would be executed?
I'm happy to do that. I would note that we, of course, don't currently manage that trust or SCANA, so I don't know the detailed history of exactly. But
if the merger occurs, you will be in control of it.
Yes, sir.
Yes, sir.
My understanding of that trust is that, as is maybe not typical, but frequently occurs for large companies, they take employee benefits and compensation that have been earned but not paid and put them in a trust of that nature for income tax purposes. My understanding is that's mostly income tax purposes of the individuals. So that is what is represented by the amount that's currently in that trust, which I understand it's consists of items that have been, again, earned in prior periods, wages and bonuses, and also some amounts that could be paid upon a change of control.
Well, thank you. I'm going to shift gears one more thing with you, and you certainly didn't hold yourself out to be an expert in securitization, but you certainly demonstrated your knowledge of it in other states and certainly at length expressed your skepticism of it, at least in this case. I want to ask you something. I realize you're the CFO and treasurer of Dominion and not SCANA, but there was a lot of back and forth about SCANA's financial condition. And in your opinion, in your current role, what is your opinion? And I know you're here as a Dominion witness, but what is your opinion about SCANA's ability to stand its financial condition with or without securitization as a standalone company? And again, I realize you're a Dominion witness, but I would like to hear your opinion if you could offer it.
My opinion is that, based on what I know, SCANA and more importantly SC&G already is experiencing some financial distress, not severe distress, but they lack full and attractive access to capital markets in many forms. They've had enough, that's for sure. In the case of a Dominion Energy merger, I think that's a moot point, as you know. In any other case, I think the answer of their outlook on a financial basis would depend greatly on what is required of them. Meaning, if they were to manage through with something like the status quo from today, I think they'd be able to manage through for some time until a very large financing or refinancing or other financial event would create a need to access capital in a material way. And I think that would be problematic.
The next huge need or of capital or some unforeseen natural disaster emergency, that's when, your opinion, when the real urgency would occur.
The real urgency, correct. And admittedly, there is not a scheduled maturity of a bond, for example, where the principal needs to be repaid. In the immediate future, to my knowledge, might be a year or two before that comes around. But other issues that would create the same kind of need for material capital from the capital markets would be settlements for issues decided outside of this commission hearing, for example. Very difficult to raise that kind of capital if there's not addressed in a remedy through this commission.
So in your opinion, they might be back sooner for a rate case, trying to stand on their own? Sooner than what you're offering?
I would imagine that would be one of many things that they would attempt to do, yes.
One of many?
One of many.
Let me shift gears a little bit. Mr. Warren, I want to go to you just a second. Commissioner Elam had asked you about one of something I wanted to probe a little bit about the federal tax credits. And one thing that has been certain since that day of August 1, 2017, when we were told about the abandonment, is SC&G has plowed in that direction of seeking the federal tax credits, and they had to absolutely, by December 31, go in that direction, and they have. And I know Commissioner Elam probed you a little bit, but with your background as a tax legal expert, what do you think the percentage chances are of SCE&G obtaining the full federal tax credits that they are seeking with the abandon? I'm talking about 100%.
Okay, that's a good question. I think first, let me just clarify that when you talk about credits, what they're really doing is claiming a deduction. And the deduction may offset taxable income, or it may create a net operating loss carry forward, as it did in 2017. But it doesn't create a tax credit per se.
Deduction for that year.
Deduction,
and
exactly.
Let me follow it up with the second part of that question. How long before we know something?
Well, I'll tell you what I know. Under the tax law, in order to sustain. The tax law allows a deduction for a loss sustained in a year. So the loss actually has to be sustained. So what this is all about is proving that SCE&G sustained a loss in 2017. Now the way you perfect, as I would say perfect, an abandonment is you have to demonstrate that you had an intent to abandon the property, and you have to have taken steps that were consistent with that intent. Now, the intent to abandon means that you're not mothballing it, you're not keeping your options open. It's done, it's closed, you walk away. That's your intent. at the point in time when you claim the deduction that you have no intent to ever proceed with that project. And to sustain your deduction, that's what you need to demonstrate. Now, as I understand it, SCANA was aware of those rules early on and adopted a course that was geared to position themselves in the best possible way to demonstrate that they met those criteria. And they took the position, and I also believe that they have actually applied to the Internal Revenue Service National Office for confirmation that what they did was adequate to sustain their position. So there is a process underway whereby they can eliminate any uncertainty associated with the deduction. Now, the importance of doing it in 2017 is twofold. First of all, if the loss is claimed in 2017, you can carry back the loss 2 years. If the loss is claimed in 2018 under the new law, you can't carry it back. So there's more cash, more immediate cash. The other factor is that when you carry it back to years in which you paid tax at 35%.
Right.
Whereas if you took it in 2018, it would only offset income that's taxed at 21%. So you have a rate differential and you have a timing of the cash, both important. SCANA recognized that and grabbed for the brass ring.
All right. Well, thank you for that explanation. Now, you acknowledge that they've applied to the National Office of the IRS, that application. In your experience as a tax attorney expert, how long, now that you've acknowledged they've applied for that, how long do you think it will be before the IRS renders an answer in your previous experience? What?
It's due. It's due soon. Now, you always hesitate to say soon when you're dealing with the IRS, but it varies from branch to branch within the IRS which subject matter you're dealing with. I would say the low side is usually 5 or 6 months. Can go longer than that. I believe we're on the far end of that, so I would think that they would be expecting something relatively soon.
Early 2019, possibly. First half of 2019, maybe.
2019, maybe. Oh no, no.
Right.
Look, if you asked me at the beginning, I would have said that is a very reasonable estimation. But there are no guarantees with dealing with the IRS.
I wish I could say it's safe to say we would not know before this proceeding's over, but who knows about that? We certainly don't expect that. As you know, we don't have any jurisdiction or regulatory authority over Santee Cooper. And I don't know if you were in here when I quizzed some of the other witnesses about the securitization of the NND assets. And I asked a couple of witnesses, both from the company and from the parties, and I know very clear that Dominion is not a proponent of securitization, but in the case of securitization, in your mind, a special purpose vehicle or special purpose entity would be created. Would that entity take title to those NND assets under securitization? And if securitization did not occur, with SCE&G abandoning these units for tax purposes, who has title to these as some people refer to them, holes in the ground or unfinished assets.
What gets securitized is not the physical assets. Okay, what gets securitized is the property right that usually a piece of state legislation creates in the recovery. So nobody cares about the assets. The assets aren't worth anything. So nobody's going to lend against those assets. What they will lend against is a state law enforceable promise that there will be a surcharge to customers over a period of time that will create a cash flow, and you can borrow against that. From a tax perspective, securitization is just like a mortgage. I mean, you're just borrowing money against a future cash flow, against a lease stream or something like that.
Okay, well, let's just throw securitization out. Let's just forget about it for a minute because Dominion's not proposing that anyway. In your mind, as a tax expert and legal expert, who has title to those assets, even though they're worthless? And as everybody says, who owns the unfinished units?
Well, I mean, whoever owns them now, until you do something with them.
Well, we know the ownership now is 55% to 45%, but if the company's writing them off, what's to say that if Santee Cooper is not sold one day that they claim title to those assets?
Okay, you're moving out of my area here. I'm sorry.
Commissioner, may I?
Yes, sure.
My understanding is the same, that the title to the assets would not change. The ownership of the assets, regardless of the amount at which they sit on the financial records, the financial books of the company, even if that's zero, the ownership of that asset, the title of the asset, it remains as currently 55-45 between SCE and G and Santee Cooper, regardless of any financing or accounting entry. That the title is retained
as it is.
As it is,
because there are other tax implications too, other than income tax.
Yes, sir. And when I say as it is, it would be until something else changes the title, which is not something that I'm aware of in the near term.
All right. Well, thank y'all. You did a good job of.
Thank you, sir.
Allowing me to go down that path. Thank you. Thank you, Mr. Chairman.
Commissioner Urban.
Thank you, Mr. Chairman. Gentlemen, thank you for coming today and making your presentation and assisting us with some of these issues. One of my concerns, and I expressed it earlier to some of the SC&G witnesses, specifically the CEO, Mr. Addison, the irrevocable trust that SCANA created to cover the bonuses and earned compensation was funded at the level of $110 million, as I understand it.
I believe that's correct.
And I'd like to ask you if you would agree, if Dominion would agree to absorb that cost and not put it on the rate base, that $110 million, since that, that I think that would send a message of good faith to the ratepayers that they're not having to pay for that. Is that something you could commit to?
I welcome input from others on the panel. My understanding is that will not be in rate base, and that's not our proposal.
All right. I just wanted to be sure of that because, if you're going to come back in 2 years, I didn't want to see that in the proposal for a rate increase.
It will not.
We have an understanding there.
Yes, sir.
All right. Would the same be true for the $1 million that SCANA or SC&G paid for the Bechtel report that was never disclosed to the Commission?
I don't have detailed knowledge on how that $1 million was accounted for in the first place.
Would you assure me that you'll look into that? Because I think, again, the public outcry and concern about having to pay for a report that was never disclosed to the Commission or to the public, for whatever reason. We've heard conflicting testimony about all that. That shouldn't be a burden that the ratepayer should have to pay.
I understand that reasonable concern.
Does that
sir.
Like a reasonable, fair request?
Yes, sir.
All right. I was looking at I was just looking at some numbers that I don't have your third quarter earnings, but I'm sure you're familiar with it. I think the last numbers I got were second quarter earnings, and so I just wanted to get an update. The numbers that I saw were that you'd grown. Well, your growth is almost 3% over the last decade, but over the last 5 years, you've had an accelerated growth rate of 5.5%, which is impressive. But back to the earnings per share, how does third quarter earnings compare year to year for Dominion?
The third quarter, in the third quarter, we reported operating earnings per share, which were at the top end of the range we had guided. It implies earnings for the first 9 months of this year to be $3.16, which is, again, a little bit above guidance. Weather was a little bit of help in that, but not much. So I think it's fair to say that for the Dominion Energy operations, everything is operating well and as expected from an earnings basis. This year, since you asked, we are growing. We do intend to grow earnings per share by about 10%. The largest single driver of that is the completion of the largest project in our company's history and in the history of the state of Maryland, Cove Point Liquefaction Project, which is one of the earnings drivers contributing to that growth this year. But in response to your question, earnings are as expected, a little bit on the top end of our guidance for the 9 months and for the quarter.
And the report that I see is you've projected to have the 6 to 10% growth rate in 2020. Is it you're kind of still on target for that?
Off of a base of 2017 midpoint, we expect earnings per share growth of 6 to 8% through 2020. Yes, sir.
Very impressive. And an overall growth, if you add the yield is where now? It's about 5.5.
Yes, sir.
And the growth, you'd say 5.8.
I believe analyst consensus is a bit higher than that. Again, 6 to 8 is our guidance, and the market expectation is well within that range.
And then you've got a tailwind from the valuation of almost 1%. Does that come from the tax savings, the new tax act?
The new tax act is a help and a hurt. Yes, sir. It's a help on a book earnings basis. On a cash flow basis, it's a hurt. But that's in those numbers, absolutely.
So my point in terms of going over all this is really kind of a good fit for you because you're a very financially stable company. You're flush with cash. You have great growth in earnings expectations going forward. So you could use the SE&G balance sheet and kind of help you in terms of writing down some of their debt problems and taking these deferred tax credits that we've talked about. That seems to be a good fit. You agree with that overall?
I agree. It's a good fit. As it relates to the SCE&G balance sheet, I would put that into two periods. One is assuming merger is successful. The initial period would be one of investment in that balance sheet, and following that over the decades to come, we would think it fit very well in an appropriately capitalized and well managed balance sheet of the overall company.
And the other thing that impressed me is that you have record-setting operating and safety performance compliance. So that speaks well for your company. The Greenville County project was on time and on budget. That's Greenville County, South Carolina, I believe.
No, sir, that's Greenville, Virginia.
Virginia, excuse me. We have Greenville County, which is where I'm from, so I wasn't sure about that. I wanted to clarify on that. And the Atlantic Coast Pipeline And supply header is running a little bit behind schedule, but that's no fault of yours. You've had some permitting issues up there. I think you're about to get resolved.
We've had a number of such issues that we're working through, but it's coming together to be on track on the new time frame.
You mentioned, or at least someone from your company mentioned, there might be ways you could help Santee Cooper because their ratepayers took a real hit in this investment as well that went sour. So I'd be interested to hear more about how you might be able to reach out to them and if you have, in fact, talked with them about ways you could be of assistance.
That's a good question. If I may defer to our next witness, which is our President CEO, Chairman.
Yes, sir.
Tom Farrell. Would probably like to talk to
yes,
that
sir.
topic.
And also, you mentioned that you'd be open to discussing an alternative form of credit for the federal government entities in our state, which are very important to our people, particularly, Fort Jackson and the VA hospital, Brian Dorn Hospital, which I'm sure they could use the cash in a form, that they would find more appropriate than perhaps they don't want cash, they want a credit.
Understand.
And so have you tried to sit down with them and try to work out a solution to that?
I know our teams have been in touch. I personally have not been.
Would you be willing to reach out to them since their representative is here today and see if you all can pass some information back and forth?
I would be happy to do that.
See if you could help them, because I know they're struggling with all kinds of problems and probably be a great help to them. We would also see that as a matter of good faith on the part of the Dominion to try to work through that.
Understood.
And finally, the Speaker's representative mentioned that a lower rate of return might bring the parties closer to agreement. Have you had any serious consideration or discussion about that?
By a lower rate of return, do you mean a lower ROE specifically?
Yes, sir. In other words, I believe you're somewhere between 9.8 and 9.1. Is that those numbers correct?
Our alternative customer benefit plan reflects 9.9, I believe.
Is that something open to negotiation?
Yeah, and Mr. Chairman, I certainly respect Commissioner Irvin's questions. I would just need to caution the witness about the confidentiality of any actual settlement discussions under the rules of evidence. But in a general sense, I certainly don't mind him answering that question.
Just trying to get the general parameters. I'm not going to hold you to any numbers. Obviously, that's a matter for private negotiations. But I guess what we'd all like to see is more progress on some of these issues. And so if that can be accomplished in an appropriate way, I think it would perhaps help everyone involved to at least resolve some of the issues.
We share that interest.
Because we have a mess on our hands. and so it's a process of trying to find the best option alternative for all concerned. And so to the extent that all these parties could make our job easier, that would be great. We would appreciate it very much. Thank you for your time.
Thank you, sir.
Thank you. Commissioner Williams.
Thank you, Mr. Chairman. Most of the questions that need to be asked have been asked and answered. But I just want to probe a little bit about what's going to happen if this merger were to occur. What's going to happen to the good folks out of that facility in Casey, the employees, and even the executive employees? Have there been any talks? And I know I've heard that those decisions are 2 years away and so forth and so on. I understand that. But I would just like to know, and I'm sure the thousands of people that are listening in would like to know, what will a merger look like for all those folks employed out there?
Yes, sir. That's a very good question. If I can just say this, when we mention our interest in structuring the economics of the transaction for all the stakeholders, we include the employees as one of those stakeholders. And we have, as you likely know, provided for pay protection for all of those employees through at least 1/1/2020. But I know your question is related to longer-term issues. And there, again, if I can repeat that some things have been said about that by other witnesses in this proceeding, including witness Colin in his testimony, that are pretty far afield. In our recent transaction history, we have quite a different picture to paint regarding what's could be expectations there. For example, in 2015, we acquired a business here in South Carolina, Carolina Gas Transmission, FERC-regulated business, and the employee reductions there were 0. But if I may, I'd like to defer additional discussion and information on that to the following panel of Dominion witnesses, Farrell and Blue, as they very much want to address that question.
And a little bit more specifically, when we talk about these executive employees, we've heard testimony that there's a trust fund of about $100 million, I believe, $110 million, that would allow for executive employees, thank you, Judge, that would allow for executive employees to get payouts if they lose their jobs. I think Mr. Addison would be entitled to somewhere around $9 to $10 million, and Ms. Griffin would be entitled to somewhere around $3 million. Now, I'm an old country boy from Wagner, South Carolina, and I don't know many people who get rewarded for driving the car in a ditch. So we just want to make sure that those types of things are taken into consideration, and some room is made for these folks. Does that make sense?
It does.
Okay. All right. Thank you, sir.
Thank you very much.
Thank you. Commissioners, any other questions? Mr. Reed, any redirect?
No redirect, Mr. Chairman.
Thank you. Gentlemen, thank you for being here today, and thank you for your testimony, and you are excused.
Thank you, Mr. Chairman.
What we're going to do right now, I know we've got another panel coming. We're going to take a break, and we'll come back to the next panel.